My clients just want justice for Maria. They just want to see justice be done. And however that comes and whatever form that comes in, they are willing to be patient with the process.
Family and friends of a cleaning lady in Indiana are calling for justice this morning. This as prosecutors are announcing criminal charges against the man who fired the fatal shot. 32-year-old Maria Florinda Rios Perez de Velasquez was shot and killed earlier this month with a single gunshot wound to her head. This after she mistakenly tried to go into the wrong home to do a house cleaning. According to police, the suspect is this guy. This is Curt Andersen. Police say he fired the shot from the inside of his home, firing through his own front door. Well, on Monday, Andersen was charged with voluntary manslaughter.
It is vitally important for the citizens of Boone County to understand that our decision today in no way should be interpreted as a challenge to Indiana stand your ground law or a person's right to self-defense. We respect those laws, believe in those laws, and will uphold those laws. Based upon the particular evidence and circumstances of this case, we have determined that Curt Andersen's actions do not fall within the legal protections provided by the Indiana Stand Your Ground law.
Andersen's attorney responded with this statement saying, quote, "We believe Mr. Andersen had every reason to believe that his actions were absolutely necessary and fully justified at the time," saying that Indiana's castle doctrine clearly applies in this case under the state self-defense laws. So the question we're asking this morning, how strong will this stand your ground defense be? Let's talk about it. Still with me in the studio, Attorney Lisa Bonner, and joining us remotely, Attorney Matt Timpanik. Matt, I'm going to begin with you, please, as you're in Florida and have a lot of experience as prosecutor and defense attorney with these types of cases, these stand your ground cases, and we know Florida has some of the most liberal stand your ground laws on the books in our country. So what do you make of the facts of this case and whether that defense is going to hold water?
It's going to be interesting because you think about this type of situation. The cleaning lady showed up to the wrong house and she was tragically, fatally killed. It's in stand your ground laws. It depends what the individual was thinking at the time of the incident, what the facts and circumstances were when they fired the gun. Did that individual fear that their life was in imminent danger? Here in Florida, there's an extra step, which requires the prosecution to prove it wasn't stand your ground before actually proceeding to trial. So when you hear the facts, you're like, yeah, no, that doesn't sound that it's going to hold water, that she showed up to the wrong house, she got shot. But it's how the defendant actually perceived that individual when they fired it. So it's not as cut and dry, and it's definitely going to be heavily litigated as this process goes forward.
Yeah, Matt, I think you hit the nail right on the head there, as you said. The details are going to be everything here. We know Indiana, Lisa, one of 31 states in America with these stand your ground laws that allow these homeowners to use deadly force to try to stop someone from unlawfully entering their home. But here, police say that there's no evidence that Florinda actually entered the home before she was shot. She was outside of it. I'd love your thoughts, please, Lisa.
That is crucial. The defendant has to show that he reasonably believed that the use of deadly force was necessary in order to neutralize the situation here. This was a cleaning lady who arrived with bucket and mop on the front door and knocked on the door. It is not like she tried to forcibly enter, like she was banging on the door, or any other instances or evidence that shows that he could have reasonably believed that she was going to break into his house and pose a threat to his person and his home. And that is going to be crucial. Were the facts presented, and did he reasonably believe that? And it doesn't seem like that, because there was no attempted forced entry. It was a knock at the door.
Right.
And it appears to be shoot first, ask questions later. That's what it looks like being. Of course, they will litigate this, but the facts at this point do not seem to rise to the level of a stand your ground case.
Lisa, thank you for that. Yeah, you got me thinking as we're talking about this, how we're looking at her behavior, right? As you said, she's coming with cleaning supplies. She's part of a crew. There were other people there, as you and Matt know. Her husband was one of the other people, so sadly witnessing his wife being shot and killed. There aren't any threats, any threatening behavior. Matt, also this homeowner, wouldn't you think most people would just look out the window? Like, if I'm not expecting someone to come to my house and my doorbell ring, like, I'm gonna look out the window and see, oh, so here's a nice lady with cleaning supplies. Like, maybe she's at the wrong place. Your thoughts, Matt, about the other facts that are absent here, an absence of threats, and an absence of anything that seemed menacing.
So one of the things they're going to look at is how the house is actually constructed, especially the front door. Is there a hole where the individual could look through to see who is at the door? Did that individual have a history that his house had previously been broken into or robbed? It doesn't sound like at that time of day that would have happened when a cleaning lady will show up. So you think it's like, what is a reasonable person going to do? Most likely, like you said, they're either going to look out the window or they're going to look through the peephole to see that, okay, whether or not that individual at the door is somebody who has a license, an invitee to come into the residence. My feeling is that it does. And you're doing that, it's like, what does a reasonable person do? Probably not shoot the person at the door without actually knowing that there's a threat. I think that we had a Florida case where a woman did that recently, where it was, there was back and forth, neighborly disputes, and that was found to not be stand your ground. It was found to be voluntary manslaughter. And unless there's different facts in this case that haven't come to light, I think it's going to be the same result.
Great points, Matt. So we know this defendant, Curt Andersen, is looking at another court date coming up and in custody in the meantime, the judge said. So if he's found guilty, he's looking at up to 10 to 30 years. 30 is the maximum penalty for the crime he's charged with. We're wondering, should he be given a bond? Let's talk about that. Should this guy be out on bond while he's awaiting trial? Now, unfortunately, we don't have access to his criminal history, but for the sake of our discussion, Lisa, this morning, let's just assume he has no criminal history. Let's just assume he's got nothing in his past that's criminal. Let's assume, he owns firearms lawfully. What do you say? Should the judge give him bond?
Well, we have to also look at other factors. Is he a flight risk? Is he a danger to society? So that is something else that the judge would take into consideration. And we really don't know that, but it does appear that his behavior was a bit unreasonable, but that's not going to be enough in the judge's estimation just to deny him bond. You do have to look at the totality of the circumstances in terms of whether or not his previous criminal history, is he a flight risk? Does he own that home, for instance? Is there going to be reason for him to stay in the state? So you have to look at all of those. So it's a little bit like reading the tea leaves at this point when we don't necessarily have enough information. But if all of those things, if he does own a home, he does not have any previous convictions or felony history or anything of that instance, the judge might put enough of a bond on him where he would, with an ankle monitor, that he would probably be entitled to bond.
Matt, I want to ask you, harken back to your time as a prosecutor or even in private practice. You do criminal defense work now in the private sector. Have you ever had a case where somebody mistakenly goes into someone else's residence or a place where it's total mistake and you have to sort it out and resolve it? Have you ever had something like this crop up?
Yes, that happens a lot more than you think, especially in cases where individuals walk into houses thinking that they are their own home, and it turns out they're not, especially in communities where houses all look the same. An individual is maybe intoxicated and they can't actually see the house numbers. One of the things I wanted to get back to the bond situation. One of the things the judge would also consider is whether or not that individual would pose a danger to the community. And with a firearm being involved in this individual shooting somebody who was just knocking at the door, that a judge would probably have a hard time thinking that individual did not pose a threat to the community, which, given what is seen in the facts and circumstances, he probably does.
Yeah, really good point to end on. Matt Timpanik, thank you so much for that. So here's what we have to do. We have to leave it here for now. This case getting a lot of traction, and whenever this gentleman is back in court, you better believe it, we're going to be there. We're going to be following this case, and our heart breaks for Florinda's family and friends who loved her so much. This is really, really a sad one.